Today is not a day to celebrate, but the arrest of Richard M. Allen of Delphi on 2 counts of murder is sure a major step in leading to the conclusion of this long-term and complex investigation. Of this long-term and complex investigation. Of this long-term and complex investigation. Of this long-term and complex investigation.
What is up, guys? Welcome to the Transparency. Good morning. Good morning, Delphi. Richard Allen, we're going to talk about it. That's what's on the docket this morning.
Was out of Indiana, the Delphi murder case. An Indiana judge, Judge Gull, has ruled that Richard Allen cannot use a third-party culprit defense strategy at his upcoming trial. This was under contention. Defense wanted to bring in these other theories.
Yeah, Odinism being one of them. Allen is charged with 2 counts of murder for the deaths of Libby German and Abigail Williams. Their bodies were found on February 14th of 2017. And we have someone here who can discuss that a lot
Yes,
more.
our senior producer, Barbara McDonald, she knows this case quite well and has known it from the beginning. Let's start with this latest ruling from Judge Gull, which seems to sort of fall in place with other rulings she has made. Defense pretty much striking out across the board when it comes to Judge Gull.
That's right. And basically, there was a 3-day hearing in July and the first part of August that went over this and gave the defense an opportunity to come to court and provide evidence that there was actually admissible evidence related to these third-party.
All right, so I'm going to go ahead and stop her right there because I want to talk about something. And we're going to welcome in none other than Hector, the projector, to talk and show us something here. Judge Gull comes out, makes a ruling yesterday that that basically Richard Allen's not going to be able to use a third-party culpability defense. But I want to show you guys a date here. Okay, up here in the corner, filed 4/30/2024. All right, this ruling just came yesterday, so September. So think about this: May, June, July, August was the long motions. And then, so let's just go with those 4 months. 4 months. 4 months. And this is what I want to point out. That did Judge Gull ever give this a chance? On April 28th, 2024 at 11:15 a.m., the court directed an email to both the state and the defense addressing various legal and logistical matters associated with forthcoming jury trial. In the second to last paragraph of the email, the court, without any prompting by the lawyers from either side, included the following statement, quote unquote, "I am quite familiar with the law regarding third-party perpetrators, and unless the defense can provide a nexus between any alleged third-party perpetrators in the charged crimes, those allegations are unsupported and will be inadmissible." The reason I want to mention this, again, she wrote this unprompted in right there, April 28th. And people out there are like, okay, well, wow, the defense had, this is their strategy. This is their strategy. And what's going to happen now? How are they going to possibly prepare for a trial? The defense would be fooling themselves if they ever thought, after seeing this, that Judge Gull is going to play ball. Okay, because she's not. All right. So they would have known back then that here's Judge Gull making it known unsolicited, like we never even talked about this. And you want to write this back again on April 28th. So did this ever stand a chance? And my answer to that, with using common sense and logic, is that it never had a chance. It never had a chance seeing this and truly looking at a timeline here. Now, let's go back to that motion in limine, which is, this is what the state prosecutors do not want in trial. This is what they filed back again, April 29th. Okay, so I was in Delphi, sat through that all-day hearing back March, it was 19th, 17th, 18th, I believe. Yeah, because it was right before my birthday. And I had a first-hand, like, boom, got to see it. There's no cameras, obviously. And Baldwin had to fight his ass off for every question he got. I mean, there was an objection being raised by Nick for every question. But to listen to Todd Click testify, because we got to, if the reports do the connecting for the defense, if you want me to be completely honest, I mean, these investigators, they were the ones, it's in the discovery, the bodies, the staging. So to sit here and say that this stuff isn't there, that's not true. It's there. Make more of a connection. It's there because these investigators that were investigating the crime put it there because that's the way that they were being led as investigators. It's in discovery. They just didn't come up with this out of like nowhere. And so, but here, want to point this out. Any comments about counsel for the state that constitutes a personal attack on the attorney for the state or comments on the role of the state's attorney. Any comments which constitutes the personal opinion of defense counsel about any evidence. Any innuendos or references that is not supported by admissible evidence. I'm going to compare this to the Karen Reed trial. You guys remember Judge Gull, first of all, or Bev, she denied the defense getting phone records from third parties. Remember that? Which would have been so helpful in the trial as we all witnessed it ourselves. But also this third-party culpability defense, Judge Bev had the same type of a ruling, all right? But what was interesting is that Lally actually opened up the door when he put these people on the stand and he tried to get in front of something, right? That's what we noticed. That's why things were taking so long, okay? It was almost like he was trying to get in front of what the defense is going to go ahead and say. Well, do you really think that Nick is going to be putting on any of these people on the stand? No. But any innuendo or reference that is not supported by admissible evidence. Ready? Any attempt to indoctrinate the jury during voir dire by exposing the jury to substantive issues in the case. Any attempt during voir dire to have the jury prejudge the credibility of a witness. Any hypothetical questions that includes facts that are not in evidence or questions that are not helpful in violation of Rule 705. I had to look into that a little bit more. Any hypothetical questions. There was times in going back to the Karen Reed case, in Alan Jackson's questioning of Trooper Paul, okay, where he actually like says, and so does Yannetti. For the sake of argument, let's say that, let's say this. That's like presenting a hypothetical. All right. And they're basically saying that's not going to happen. So in the Franks 1, when it goes through and talks about how there is no way that one man did this, all right? Are you going to sit here and tell me that they're not allowed to bring that up about one man, that this couldn't have been done by one man? Because I just think that that's common sense. Like, talk about the crime scene. Any attempt to introduce evidence of third-party motive that is not relevant, and or, this is where she uses the quotes, and we're going to go back. I'm going to cue this up because I'm going back to this. Go back in here. What's her name? Here she is.
Party culprits that they wanted to point at. And the judge said after that hearing that she was not satisfied that they had done that they had not presented anything that was admissible in court, showing that these people were at the scene or were not where they were supposed to be at the time. And so the judge is saying, no, you're not going to be able to bring any of this in. But the state's motion in limine was asking for a whole lot more than just limiting this third-party defense. And so some of the other things that the judge has said is not going to be allowed is any reference to even the investigator who looked into the Odinism theory. You know, that was a route that investigators had followed in the early days of the investigation. They said they didn't find anything that led them to believe that that was actually what was involved here, and so they stopped pursuing it. But those materials are what the defense has seized on, and they're not even allowed to mention the detective who looked into this and wrote that initial report about Odinism. His name is Todd Click. He is now...
There you go. Boom. How is this legal? How is this? Wait, excuse me? First of all, let's just put this out. All right. If the prosecution, before it came to them, normally what you do in an investigation is you start eliminating people. So in order to eliminate people, you do some digging, you do some questioning, you do some interviews, they give you some answers, then you go and corroborate those answers. And it's a process of elimination. We want to eliminate, you guys always hear that. We want to eliminate you as a suspect. So work with us so that we can eliminate you, right? Well, where's the evidence in discovery of the police doing that in the investigation to eliminate the people that the defense is talking about? Where is that? And this Monday, I have a really special guest that's going to be coming on the show from Criminality T, Teresa. We are going to do a big old live for you guys on the Delphi case. And one of the main things that we've both been saying is something to that effect, which is, you want to tell me that I can't talk about these people. You want to tell me that I can't reference these people. You want to tell me all these things. Why don't you just show me why they're not relevant and show me how you excluded them because you did the proper investigation? Oh, wait, that's right. You can't provide me with that, right? So then you have to ask yourself, how? That should be something that's so easy. But it's not there.
Is now retired, and his name isn't going to come in either. There's also not going to be any reference to the geofencing data, which the defense has indicated in filings, shows that there were other phones walking around the crime scene during the time that the girls were missing and their bodies hadn't yet been discovered.
How is that not admissible? Do you guys just hear that? That's what Cy does for a living. Okay. Can you imagine going and getting like a Cy or an expert, somebody that, no one's going to be an equivalent, but there you go, Cy, there's your nod. But wait, what? The geofencing is part of the discovery. How are you going to tell me that I can't use stuff that's in the criminal discovery? Do you guys hear, where is the logic and where is the common sense? But I think that's going to trump it all is, how is this fucking legal? How is this legal? How is this legal? You know, think about it. If I tell you that I didn't do it, hey, I didn't do it, somebody else did. Everybody out there that says that they're innocent in the world, they don't say I'm innocent because the crime didn't happen, okay? They say I'm innocent, I didn't do it, somebody else did, all right? They don't say I'm innocent because there is no crime, nothing happened. I'm innocent, so, because I can see then you can't put forth something. If there is no crime, then yeah, there's no third party culprit, but no one's ever screaming that from the rooftops. No one's ever saying I'm innocent because there wasn't a crime. They're saying, I didn't do it. You got the wrong guy. You got the wrong girl. I'm innocent. Somebody else did it. So how you could ever, like, something needs to change here. Because if what Judge Gull literally did in this case is legal, then something needs to change. Because it's not like the defense went out and got their own evidence and is saying, we want to put this in. We did, like, we got investigators. They went out, they did interviews. We want to put this stuff in. It seems this would make it so one could not defend themselves. Well, it seems as if we're playing baseball and you get 3 outs and I get 1 out per inning. Okay. And guess what? The justice scales and the blindfold, it's supposed to be even, right? And this is what it's doing right now. Okay, how can anybody go to court and win if I don't have, if we have different playbooks, if we have handbooks, rules? It wasn't just that Judge Gull came out and said, listen, you're not going to talk about Odinism and you're not going to talk about freaking, people out there doing sacrificial rituals and blah, blah, blah. Okay. But there is a direct link with Brad Holder. That was Abigail Williams's boyfriend's dad. We're not talking about some random. Okay. We are talking about a direct link. That is the father of her boyfriend. Also, if the defense's theory is at the time of the crime is later, okay, or there were 2 crimes here and that there was an abduction and that they took him away from the water, the bridge in that area, and that they came back to that area later, okay, and that the crime didn't happen till later, or one of the crimes, which would be the murders, how is that also not legal to present? Because then Brad Holder's stupid alibi that he was at work and that he clocked out at this time and it takes this long to get there. Well, it still goes in line with what the defense is saying, that multiple people were involved in this. And Brad Holder, when he got out of work and showed up, is when he got out of work and showed up, because this all happened later. But the abduction happened at this time. And so how can that confuse the jury that you want to say that the crime happened between this time to this time and it's one person? Well, we want to say that the crime happened it started at this time, but it carried on, okay? Because we're talking about multiple crimes here. We're talking about abduction, then we're talking about the murders, then we're talking about moving dead bodies, concealing them. That's a separate crime. We're talking about conspiring. We're talking about, there's many things that happen in this case, and it's not just a murder. Hence, why did when they arrested Richard Allen, they amended the charges and they added what? Kidnapping, right? That wasn't ever a charge. So let's go back to, so my argument here is how I would be arguing it is that you guys say the time of the crime is this time, but I'm saying it's this time. And as a defendant, you most certainly have that right. Okay. That's like the Karen Reed case. You guys say that John O'Keefe sustained those injuries at 12, basically 36. All right. Or I'm sorry, 12:28 p.m. Well, no, I think that John O'Keefe suffered injuries twice, because when he was put outside, that would be when he suffered the hypothermia. But him getting his ass beat inside that house in the basement, that happened earlier. And then when he was placed outside later, that would be, so we're moving the time of the crime in a sense, right? Because it is a crime to knowingly leave somebody, like they charge Karen Reed with, the count 3. All right. So I like to use other cases to compare it to, like, to help people like understand maybe that aren't familiar with this case.
And so the judge is saying that also is not going to come into this trial. The other thing that I think is rather interesting.
Geofencing, guys. Geofencing that was in the discovery that shows that other people's phones were there at the time that y'all said the crime happened. Going back to, good morning, everybody. Welcome. Going back to Hector here. Good morning. Okay. Any attempt to introduce third-party motive that is not relevant and or probative value. That's what she talked about, and she quoted Judge Gull talked about that it does not outweigh. So she doesn't believe that the probative value. So what she's trying, like right here, it's like Nick with this motion in limine, like basically gave Judge Gull, here, this is exactly what you're going to do. Okay. Before any such evidence may be permitted, the defense must show some connection between the third party and the crime. All right, so let's talk about that just for a little bit, between the third party and the crime. Again, wouldn't you think as an investigator, so think about this. If I'm Richard Allen and there's something that's called rebuttal witnesses. And for example, I'm just going to use the Jennifer Drake, Brian Drake, Dr. Moore case. Idaho State Police is saying that the bullet came from outside in, from that window. Well, wait, no. So my theory is that Brian Drake was killed outside, then put back in his office. Then the window was shot out to stage the crime scene, right? And I have an expert in ballistics. I have an expert in crime scene reenactments. And most importantly, like we're going to do a reenactment here of just science and show you guys, take that window, shoot it out from the outside, take that window, shoot it out from the inside. You're telling me that I'm not allowed to have a rebuttal witness to talk about the crime scene? An expert with crime scene evidence? Wait, excuse me, because come again. Exactly. FBI assessment proves third-party culpability. It's in what's his name's probable cause affidavit. Ron Logan's talking about that. The FBI component says that the crime scene was staged. So going back to this case, it's like you're telling me that Richard Allen isn't allowed. So let's go back to this. It says, before any such evidence may be permitted, the defense must show some connection between the third party and the crime. Well, the crime would be considered also the crime scene, right? And so these guys are going to get up there and talk about when they arrived in the crime scene, but you're going to sit here and tell me that I can't have rebuttal witnesses that are going to talk about that crime scene, where the blood would be, where the blood is not on any of the clothing, how they have different, like they were stripped down, all of this stuff to combat the fact that one perpetrator, to combat the fact that it was staged, to combat the fact that only one person did this. But here you're saying, okay, that's fine, but you have to draw a link. So in order to talk about third party, I have to have a link, right? Well, wouldn't the link be that would it not be enough that if somebody is posting stuff on social media that is mimicking the crime scene, wouldn't it be enough that the person is the dad of the boyfriend? Wouldn't it be enough to talk about the inconsistencies in the statements made by that person when they were interviewed? Wouldn't it be enough to show that this man doesn't go out to the woods by himself, but he goes out with other people? And we're saying that the crime was committed by multiple people. Elvis Fields telling his sister what? That if you find my DNA, I spit on the bodies. Wouldn't it be enough that there's unaccounted for DNA at the scene that does not match Richard Allen? Wouldn't that be enough to say that, okay, for example, what if Ann Taylor wanted to use it, that this crime was committed by more than one person with the Brian Kober case, right? And there's unaccounted for DNA. And then we show the wounds. Maybe they can get away with saying that knife that y'all claim that's the murder weapon that fits in that sheath, no way could have made those type of wounds. Something like that, right? But then how about this? How about Libby's phone? How about Libby's phone registering at 4:30 in the morning? Because they used the time of the crime. Because they said that her phone, there was no more activity on her phone. And that wasn't true. There was activity at 4:30 a.m. None of this stuff is enough to show that we're saying the crime happened later. We're saying it was done by multiple people. And so when somebody like a Holman gets on the stand and the rest of the clan, okay? Anybody that's a Delphi, when's the last time you worked a murder case in Delphi, officer? You haven't. But they're not even going to be able to use Todd Click. I don't understand how none of this is. I agree. This is happening right in front of our faces. And this wants to be a closed trial. Further, it must be a direct connection based on admissible evidence and not founded in hearsay. But guess what, guys? There are exceptions to the hearsay rule. All right. If Jennifer Drake, it's the utterance of, if somebody says something to you and you utter something, or they utter it to you or they scream out, okay, that beats the hearsay exception rule. So if Brad Holder's wife, Amber, all right, was told something in a rage of this man, and it was frightening, and oh my God, like it's the utterance of excitement, fear, shit like that. That is a hearsay exception. And so Amber, the wife of Brad Holder, this is like their way of being able to keep stuff like that up. But I personally believe that it beats the hearsay. It beats the hearsay rule because it's one of the exceptions. Amber Holder was in the courtroom when I was there in March, set to testify, got up in the stand. Nick, every question, objection, relevancy, objection, like I told you, Baldwin couldn't get questions in. He had to be so, they were voideering people. It was wild. It was nothing I've ever seen in my life. And that's why this needs to be on television so you guys can just see, like, state your name, objection, Your Honor. State your name for the record, objection. Sustained. So the state requests such order in limine to include, but not limited. What do you mean not limited? So what else do you want to but not limited to? So what else is there? But not limited to. Odinism, cult, or Brad Holder, Patrick Westfall, Johnny Messer, Elvis Fields, Ned Smith. Why? Look at this. Any reference to an investigation conducted by Todd Click, along with any reports or investigative materials from Todd Click, that's the testimony that I got to hear, and it was bomb. He's so credible, guys. And that's why they cannot have him anywhere near this. That is not relevant or is used for the purpose of confusing the issues. To mislead the jury. So he would be like a rebuttal witness, okay? How is he not considered a rebuttal witness? If you get to talk about what you think this crime scene looks like, why can't I use a guy that was also involved in the investigation to tell us what he thinks about this crime scene? Ron Logan. It was on his motherfucking property. How are we excluding Ron motherfucking Logan? You guys, I mean, what? I called a couple of these people. Elvis Fields making admissions to his sisters. How is it hearsay if we bring in the sisters and they testify? We'll bring in Elvis Fields. He can testify too. You get to cross-examine both of them. Any reference to geofencing and or any testimony from, dude, this is the guy that they used. That's your FBI dude. Any reference to geofencing and or any testimony from Kevin Horn about geofencing or the findings from any geofence search that is not relevant or is for the purpose of confusing the issues. How is it not relevant that there were phones or walking around the crime scene during the time of when the state is alleging that this was occurring? How is that not relevant? Burden is on the opponent to show why it is relevant. Because my client is saying he didn't do it, Your Honor. That's why it's relevant. It's saying he didn't do it. He wasn't there. And there's other people that are. What the state is alleging that happened, it's relevant because what the state is alleging that happened could not be done by one person. Even, how about that? So are they going to have to change their, hey, you know what? My client did it, but he didn't do it alone. Is that what you want us to say? So he should give another false confession because all the 100 that he gave are all different, which go read Jane Fisher's. She's an expert in false confessions. I had the privilege of meeting with Jane Fisher personally. And Lana, if there's when you say you make a confession and any part of that is not true, the entire confession is false. Okay. Now, when you make a confession and then let's say you make another confession and it doesn't mirror that same confession, now there's two false confessions now. This man, Richard Allen, literally has never said the same thing twice about these confessions while he is eating his own feces. It's never been heard of that somebody has ever confessed 60 times when you ask these experts. That's like unheard of. Let me tell you also about another thing about a false confession from one of the great docs out there. Okay, let's move some of my stuff around. Okay, one of the greats out there. Good old handy dandy here. Let me tell you something about that. All right. A false confession, so I want you to think about these three things. When it can be objectively established that the suspect confessed to a crime that did not happen. Okay, obviously, right? Number two, when it can be objectively established that it would have been physically impossible for the confessor to have committed the crime. Physically impossible. So in the Franks 1, when they go through that section that says, the state's theory is that a single solitary man did this, and then they list up all these things. It was like the best Franks I think I've ever read, like to date in any case. And when you hear that and you listen to what they're saying happen, that, in my opinion, is number two. When it can be objectively established that it would have been physically impossible for the confessor to have committed the crime based on that, like, when the true perpetrator is identified and his guilt is objectively established, or four, when scientific evidence positively establishes the confessor's innocence. So basically when the crime scene doesn't match the confession, right? Now, all right, so how about this? In my professional opinion, blank's confession statements to blank is almost certainly, if not certainly, false and unreliable. The confession statements does not bear any of the traditional indicas of the reliability that scientific researchers and experts use to assess confessions based on the evidence. It is not based on the evidence. It is not has not led to new, missing, or important evidence that based on that person's confession that you guys got something from it. Okay. It did not contain any corroboration, non-public case facts that only the true perpetrator would know. And it is inconsistent with and contradicted by numerous other case facts, logic, and evidence. Now, this guy will set you back a pretty penny if you want him. So I can't wait to hear these confessions that Richard Allen gave, because I guarantee you it does not meet anything what I just said, which would be you hold things back so that when somebody that is the true perpetrator and when they say something, it's like, okay, nobody knew about that. How do they know about that? And it matches something. Okay. One of the best right there. It's physically impossible because Rick was not that big. That's the lot of it. Yeah. Right? Absolutely. All right. So right here. Geofencing. We're going to talk about that. Actually, we'll let Barbara here because this is what she said she was surprised on. And for those of you guys, there you go. You can hear this.
Interesting is the state asked to prohibit any reference, and this is a quote from his filing, from Nick McLeland's filing, any reference to any prior bad acts or acts of any witnesses that plan to testify. And so it's going to be really interesting. There are obviously a lot of people who follow this case who think that this judge is biased against the defense and the defendant, Richard Allen, who you see there on your screen. He has been subjected to some very harsh treatment during his incarceration after his arrest. He is now out of the maximum security prison system and is in a county jail awaiting trial, which is supposed to happen next month. But Julia, I've heard you talk about this quite a bit, that these motions and these early decisions set everything up for the tone of the trial. And that's what's happening here. The judge in one motion is saying a lot of this stuff is not going to come in.
It certainly changes the landscape of what we are going to see at the trial. My question is, I know you've been watching all of these motions and pouring through them as they come in. We've watched this case shift and change, but what's left? If the geofencing is out, if the third-party culprit defense is out for these defense attorneys, what do you think is going to be their angle at trial?
It's going to be tough. You know, there are a lot of attorneys discussing this case on social media who are commenting that this definitely sets this case up for an appeal. One even worded it that this ruling basically makes this first trial a practice run, which I know nobody involved in this case wants to see happen.
That's exactly what's going to happen. So Indiana, the taxpayers there, and they were all complaining about how much this case has costed them. First of all, this case has costed y'all pennies compared to what truly this stuff costs. Okay. You guys, genealogy was done in this case. $20,000 was put up and paid for genealogy. There is a fucking tree out there. Okay. CC Moore and company, and this little groupie group of the genealogists out there, they know who they are. $20,000 was paid out for genealogy. Now, last night, people want to say that Becky Patty said that CC Moore said that she offered to do it for free and stuff like that. I don't believe anything that anybody says. We saw the bill. Either they fudged the bill and they just wrote down that genealogy was in there for 20 grand, or there's a freaking, there's some trees out there. Okay. There's some trees out there. And guys, in order to do genealogy, you have to have DNA. Okay. So let's think about that. Oh, wait, that means there's DNA at the crime scene that's relevant and it doesn't belong to Richard Allen. That'd be like this. That'd be like saying in the Idaho 4 case that a sheath was found that there's DNA on it, but we were never able to link it to somebody. Do you think that that's relevant? Nope, you're not going to use that. Wait a second. Just think about that. What if they never got a hit in the Idaho 4 case on the sheath, on the DNA? They weren't able to, fuck. Yeah, but it's there. But it's there. But it's there. I put 1,000 that it's semen. Well, of course it's relevant, says Lucy, Sleuthy Goosey. Of course it's relevant, right? But think about how crazy it would be, Judge Gull making a decision to say that, nope, we're not going to talk about the, like, so can the defense talk about the genealogy that was done in this case? And why they went to genealogy? They thought it was going to help, right? Did they put that DNA in CODIS? No hits, right? If they compare it to Richard Allen's, obviously we'd know if it matched. But I can't possibly think that you could sit here and tell me that if they would have never been able to link the DNA on the sheet to anybody because it just didn't work out, like it didn't work out in the in this case. When they brought in genealogy, they weren't able to allegedly, or there are trees floating around there and there's people like, hey, this is the work I did. Here it is. These are the people that I linked it to. So can you imagine Ann Taylor being told that she couldn't use the fact that there was DNA in a sheath underneath the victims, didn't match her client, but that's not relevant? So there's DNA at the crime scene that does not match Richard Allen's. It's all going to come into play when they're going to talk about, well, where is this DNA? Well, what were the girls doing the night before? Who's to say that it's not semen? Just because it wasn't a sexual crime, that doesn't mean that nobody didn't have sex the night before, and there could still be semen. So I'm curious to see what type of DNA it is and where it was found.
Happened. The families of these poor girls, they've been waiting 7 years for justice. The arrest of Richard Allen came almost 5 years into this investigation. They are ready to move on to the next chapter of their grieving in all of this. So it's going to be really interesting. But, Richard Allen's own words place him at the trails the day the girls went missing, around the time that they were missing. We don't know if there's any phone data, since it was 5 years later that he was arrested, that might show where exactly he was during those times. But right now it sounds like it's going to be his word against what the state has to offer.
And there's no Ron Logan.
So oh, wait, here, listen.
No Anthony Schatz.
No Ron Logan, no Anthony Schatz. Anthony Schatz was somebody that law enforcement asked people to help them with information on. He was catfishing girls in Indiana, asking for nude images. He has since been charged and sentenced to 43 years, unrelated to anything having to do with Abby and
in
Libby.
communication with the girls, right?
He definitely was in communication with at least Libby. And then Ron Logan was the man who owned the property where the girls were found, and he lied about where he was at the time they went missing.
And none of this
he was charged with probation violations. He spent a year behind bars and a year on house arrest. But, these are people that law enforcement has never come out and said for sure that they are cleared. With Ron Logan, with Kegan Kline, they did say they could never place him in Delphi, but Ron Logan lied about where he was, and we still don't know exactly where he was at the time the girls were being killed, and that's another issue for the trial. Law enforcement has been unable to come up with a time of death, so it leaves a lot of questions about exactly who was where when.
So the best thing is that the question everybody can ask is, what's left? Okay. What's left? When you take all of this out, let's go back to Hector here. Again, welcome, good morning to everybody. We're talking about what's left. All right, any reference to geofencing. Hey, guess what, Cyree? You ain't needed no more. Location data. Dude, it's 2024 and location data. This is not relevant. Phones in the area are not relevant. You guys, this case on its face would cause every other case that's been pushed through the judicial system I'm going to go appeal my case, because over there in Indiana, man, they said all this stuff is just irrelevant. Like, it doesn't stand a place in the courtroom. So, let's go. Right? Like, what? Okay. Any reference to any prior bad acts. So we're not allowed to impeach anybody. So we're going to take impeachment. We're going to, you can't impeach people based on, any reference to any reference to any prior bad act or acts of any witnesses. Any witnesses. Do you understand that that's absolutely fucking crazy? That plan to testify at the trial that is not relevant to what the defendant is on trial for. Excuse me? If you're coming here to talk about something, you're talking about what he's on trial for. And I don't have the right to impeach him. I can't throw reasonable doubt to the jury to show, do you really want to believe somebody that in the past has been charged with, obstruction of justice for lying to a police officer? For sex acts? I mean, how about this? Why do you have to ask for all of this stuff if your case is just and he's just the man? Any reference to how the files were labeled that were handed over to the defense as part of the information discovery provided. Well, he put that in there so they can't say anything about the jailhouses. I even think it's more than that. So what's left? Any reference to how the files were labeled? How were those files labeled? Again, this all goes to the fact that this is going to confuse the jury, right? Any reference to any PowerPoints provided by the state. we can't use the state's own material in discovery. I just don't. Again. So going back to this, which is unprompted on April 28th, Gull just writes this in. I am quite familiar with the law regarding third-party perpetrators, and unless the defense can provide a nexus between any alleged third-party perpetrators in the charged crimes, those allegations are unsupported and will be inadmissible. Okay, so then let me show you this. So how, again, I just want to put this out there. How is Brad Holder not relevant? On February 17th, documents specifically sought by the defense, Doug Carter's emails with the FBI, provided evidence that Brad Holder was a suspect within days of the murder, and certainly on February 17, 2017, when Holder interviewed at the Delphi police station and turned over his phone to law enforcement, but they don't have the extraction. State Police Superintendent Doug Carter was aware that Brad Holder was a suspect. So, is it going to be like the Karen Reed case to be able to get it in like this way? Well, the defense calls Doug Carter to the stand. Are they going to call Doug Carter to the stand and be able to say, during the course of this case, how many suspects did you have? Like, let's go start from the beginning here. Who were the persons of interest in this case? You're going to sit here and tell me objection, Your Honor, relevancy. Well, Mr. Baldwin, what's the relevancy here? Well, it's relevant because it's how you got to my client, right? Nope, excluded. You know what I'm saying? Like, think about that. Mr. Carter, or whoever is on the stand, when would the door become opened? And see, that's what the public should be helping. If it was a public trial, people would be able to be watching this and see if the prosecutor slips up and you ask a question, or the witness slips up and says something, that they would then open the door. It being on his property is enough. Exactly. Yes, they've asked for recusal. She refuses. There's no doors, only warm holes. Even the top FBI agent in Indianapolis, Jay Abbott, was aware that Brad Holder was a suspect. Logan Holder was not mentioned as a suspect in these emails, but they got his phone. And that's the boyfriend. because they did tons of depositions in this case. Brad Holder's missing phone extraction data. During a recent deposition of Brad Holder, the defense learned that Brad Holder is pretty sure that he turned over his phone to law enforcement on February 17th. Prosecution has not turned over any data, extractions reports, or other evidence from Brad Holder's phone. Because this is, remember, this was the motion that Richard Allen's defense team filed in its second motion to dismiss based upon newly discovered, destroyed, and or missing exculpatory or potentially useful evidence. Okay. This is great. Now, again, this is from the defendant's response to state's motion in limine. So what I just went over, that's what the state wants to like have out, right? And so the first thing is boom, you prompted this. Nobody even talked about it. All right. And then they go ahead, look at the date of this filing. Filed 4/30. And this was filed 4/28, yeah. So 4/28, the same day of the filing, or I'm sorry, 4/29, a day after this email goes out, where it was unprompted, and the judge just puts and talks about third-party culpability. Then the next day is, oh, that was filed, which is the motion in limine on 4/29. So timelining it all right? And Richard Allen's team is not fucking stupid. They're catching on to all of this. All right. And so that's the motion limine just read. Now here's the defense's response to the state's motion in limine and request for hearing. And look at, they filed it on 4/30. And this was filed on 4/29. They already have a response, man. Boom, here you go. Let's talk about your bullshit here. On April 29th at 12:09 a.m., the state without hesitation accepted the court's invitation to limit evidence regarding third-party perpetrators. Now look at that. Look at this. Hey, Goosey. Have you put together like a, that's what I'm working on right now, is to put a timeline together, like to show just how crazy this truly is. And if this does not show that a prosecutor and a judge are like working hand in hand, I don't know what does. Okay. The court has established a pattern of just similarly denying pretrial evidentiary motions filed by the defense throughout this case. The motions have been denied despite the defense supporting many of its motions with an evidentiary support in the form of video interviews, audio interviews, crime scene photos, affidavits of witnesses, and various other forms of corroborating documentation. But yet you just, boom. Just, without even, denied. In contrast, the state's motion in limine contains no supporting documents or other information justifying any limitations on the defense's ability to present evidence regarding third-party culpability. Do you have the email itself, Lana? The email that I think I do, actually. If you want to send it over, I can pull that up. But I think I actually have it. I'll double check. Let me see. I think it should be right here. Gull's email about the third party. Yeah, I think I have it actually right here. Let me see. Gull. I got so many emails of hers. Where is it? Well, if you have it handy by you, if you want to email it, you can. I don't know your email. Oh, the mind challenge. There you go. So then think about this. The defense has just been loading all of their stuff up with, oh, here's exhibits. Here's all this stuff. We're supporting why we're doing all this. And then the state just writes it, doesn't support it. And so literally the defense is like, we're going to answer this right away. So in contrast, the state's motion limine contains no supporting documents or other information justifying any limitations on the defendant's ability, right? Defendant Allen's defense team is quite familiar with the law regarding admissibility of evidence of third-party perpetrators, which requires only that the defendant, Allen, establishes some connection between the third-party perpetrator and the crime. Keyword I believe is some. The court must balance defendant Allen's Sixth Amendment right to present a defense with the state's desire to limit such evidence. So right here, I told you what we would be writing down. Sixth Amendment violation, in my opinion. Right off the rip. And then what's left? If Richard Allen can't use these things, and that's what's going to be the title on Monday. Remember, Teresa's going to be here. So what is left? And what that means is, what can Richard Allen fucking use to defend himself in a capital case? This is crazy. Oh, I did have your email. Oh, thanks, Lily. Yeah, and if you want to clear your schedule on Monday, let me know. I wanted to have a banging Delphi deep in the cut. What's left? What is left? Okay, what is left? You guys want to talk about violating rights? Whew. The defense has spent the better part of a year conducting discovery, seeking out exculpatory evidence from the state, and developing credible defense-related theories, which the defense intends to present to the jury in this case. The state of Indiana has sought out no assistance from the court in any attempt to limit the discovery process. In fact, the defense has conducted numerous depositions involving third-party perpetrators without the state seeking any orders of protection or orders limiting the discovery process. The defense anticipates that its trial presentation will include somewhere between 1 to 2 dozen witnesses. You guys know what 2 dozen is, right? Remember, this was filed 4/30. Okay. They had a huge back-to-back-to-back 3-day hearing in August. And then Judge Gull comes out yesterday and says, guess what? Court starting in the middle of October, or was it October 7th? October 15th, something like that. We are, whoop. And guess what? Y'all got about 30 days to figure something else out. Oh, I got your email. If you just sent it. Open. Yes. I have it in my, thank you. I'm gonna print this. Just will download. Print. Print. What's available? Okay. Thank you. Thank you there. You got my email of the email. Yes, I got your email of the email. Again, welcome everybody. Come on in. Talking Delphi. Talking, woo! Let me just make this clear. All right, so To the extent that the court carries out its warning referenced in the April 28th email, ta-da! Okay. The intent is that jury selection will take 3 days. Court will be in session in Allen County beginning at 8:30 a.m. and concluding when we conclude for the day. Like, bitch, we don't even get to give you a time. You guys, who is this one? When we, remember when they did the 3 long days? One of the days wasn't until what time? Dude, she really means that. She really means that. Like, she's not doing like a 9 to 5. Like, this woman does whatever the fuck she wants. And I mean, that's great. I do too. But I don't need to go violating other people's rights to do whatever the fuck I want. But she does. Remember, this is an adult show. I have no problem saying, what the fuck? Dude, this is crazy, guys. This is our rights. You have all been provided with the sub-panelists broken into morning and afternoon sessions. I will forward to you under separate email the seating charts for courtroom 1 and the strike sheets we will be using for selection. The selected jurors will be sworn in upon selection and ordered to not speak or communicate with anyone about the case and to conduct no research. Remember, they're sequestering this jury. They will further be ordered to return to the Allen County Courthouse on Thursday morning with their luggage and personal effects, which will be searched by law enforcement officers to ensure they are bringing nothing electronic or illegal. We are not letting people get high as kites. Once it is complete, they'll be transported to their hotel by my staff. The order I referenced above contemplates an invitation to the media to meet with me in the Carroll Circuit Courtroom Thursday afternoon so that they can take photographs of the empty courtroom and B-roll footage of the courtroom for their stories and broadcasts. You guys, wait, when is this happening? I have to get my B-roll. She even knows about the B-roll footage. Oh my God. I need my B-roll, bitch. You guys, when is this happening? Thursday? All right, that's the day I need to be there so I can get a picture of her and her B-roll. You guys, what the fuck? Of the courtroom for their stories and broadcasts and to receive their press credentials. Well, I'll be getting my press credentials, okay? For this case, you had to prove that you were new media, right? Doing write-ups, doing you had to be talking about this case for more than, same thing with the Shannon Gardner case, because I'm working on my press pass there. I was like, what are you talking about? You could just give me whatever the hell I want, but I'm under new media. This case was set as a speedy trial at the request of the defendant for May 13th to 31st. That is the length of the trial, not more or less. When the order was issued, not one attorney notified the court that the length of the trial was insufficient. In fact, it is consistent with the previously scheduled length in January of 2024. I intend to start court every morning by 9 a.m. and recess for the day around 5 to 6. Now she gives us a time. Fucking idiot. This is what her intentions are, but we'll see. Court will be in session on Saturday, perhaps for the entire day if necessary. I forgot about Saturdays. That's what I'm going down. I'm going down on Saturdays. Giving up my Saturdays, guys. I'll be down there. I got my megaphone ready. All right. Saturdays, perhaps for the entire day if necessary. Court will be in recess on Saturday or on Sunday to allow the jurors and the parties to rest. I have tried death penalty. And life without parole cases in this amount of time, all of them with multiple victims. I am aware how many witnesses the prosecution intends to call, nor on how long their case. What? I'm unaware. I'm unaware how many witnesses the prosecution intends to call, nor on how long their case will take to present. The defense is claiming it will take a couple of weeks to present its case. I am unsure what exactly the defense intends to present. Why? Doesn't matter. You're not going to know shit. I am quite familiar with the law regarding third-party perpetrators, and unless the defense basically, oh my God, she's saying, I can tell you right, it ain't going to take, 2 weeks to present your case because I ain't going to let you present a case. Because Fran Gull seems to think that it's the state's burden. And then you guys are just going to sit there and poke holes at it and use cross-examination to, tear apart this case. Fuck our experts. Fuck our rebuttal witnesses. Right? She did a death penalty case in 4 days, guys. Because she's so proud. Please be prepared to present your cases timely. Have your witnesses available quickly and promptly. I look with disfavor on counsel attempting to manipulate the presentation of evidence by timing witnesses poorly. I look with disfavor. That conduct will not be permitted. The jurors' time is valuable, especially since they are sequestered and away from their homes, families, and jobs. Please respect the sacrifice the jurors are making. Get the fuck up out of here. What an absolute, what a trifling woman. What a trifling woman. So then looking back over here, so here she found out that, hey, we're going to present 1 to 24 witnesses, in case you guys did not know. And then says, to the extent that the court carries out its warning reference in the April 20th email, the trial will be reduced to unnecessary delays due to lengthy offers to prove and lengthy delays due to large gaps in the scheduling of witnesses to appear for trial testimony. The absence of any articulated and reasoned legal guidance from the court in advance of the trial would promote the lack of judicial economy throughout the proceedings. Yeah, she's pure trash. The defense requests the court set the state's motion limine for hearing for a full day during the week beginning May 6th. They wanted May 6th. Do you guys know when this happened? At which time the parties would be entitled to present evidence regarding admissibility of third-party perpetrator evidence. This approach to the business of jurisprudence would assist in clarifying the nature and scope of the evidence to be admitted at trial, which would benefit both parties, the court and the jury. In its motion in limine, the state requested to limit evidence regarding several other matters. The defense response to each request for limitation instructions is as followed. Paragraph 1, state requests relief from any comments about counsel for the state that constitutes a personal attack on the attorney for the state or comments. What is crazy? Let's see. They just answered this right back. States paragraph 2, the state seeks to limit the defense from comments which constitute the personal opinions of defense counsel about any evidence, witness, outcome, or penalty. The state provides no specific facts or documentation supporting its request for a limiting instruction. The request is unsupported and should be denied. States paragraph 3. The state seeks limitation on the defendant or on the defense as it relates to innuendos or references that are not supported by admissible evidence. The request is overly broad, unsupported by factual allegations, and therefore should be denied. States paragraph 4. The state seeks to limit the defense ability to conduct voir dire through the introduction of substantiated issues in the case to the jury pool, the state provides no specific reference to what issues should be limited. Overly broad, denied. This is how they feel, the defense. The state seeks to limit the defense's ability to question potential jurors about their feelings about the credibility of certain anticipated trial witnesses. The state seeks to limit the defense from introducing hypothetical questions that include facts that are not in evidence or questions that are not helpful in violation of Rule 705. The state's request is overly broad and contains no specific facts or issues for which said anticipated hypothetical questions would be addressed. Paragraph 789, C360. We're not going to keep writing this shit. This is great. The state seeks to limit the defense's ability to challenge the state's geofencing expert, Kevin, based on relevancy. The state's request is overly broad. It's just like they're reminding her. The state seeks to limit the defense's ability to challenge the state's geofencing expert. It's their expert. Like, how is the fuck is this? What is going on? But guys, the best part about all of this is they wanted this all handled in May. This is getting handled and just handled yesterday. In trial literally is in like 30 days. The state seeks to limit the introduction of prior bad acts. Remember that? Okay, so the state seeks to limit evidence related to its own failure to provide the defense discovery consistent with the local rule regarding discovery. However, the state provides no specific facts to support its request. The state seeks to limit the defendant's ability to offer up PowerPoint presentations that were created by the state and its investigation team. You guys, guess what? We gave you all this discovery, but you ain't allowed to use any of it. Excuse me? Huh? Come again? Is this real life? Yeah, it's real life. And guess what? Is the state bipolar? No, they're just inept. We can't have our ineptness be shown. So then the question comes back is, what is left? What is left? How do you defend Richard Allen? What's going to be allowed? What's not going to be allowed? Okay, so I guess we have, okay. Cross-examination. That's how you're going to get your reasonable doubt across. Yes, Annie. Sorry, I'm driving. Did I hear that right? The state is seeking to limit their own witnesses and evidence? Yes. Yes, their own people, their own discovery. So, like, how do you defend? What do we do? Or what do they do? But they knew that this was coming. Truth and transparency. Is there no way an entity step in before the case, or will it have to wait? You guys, I'm telling you, Nick objected to every question when I was there. I was like, come on. Hold on. Let me show you guys something. Okay. The exculpatory nature of the missing evidence. Currently, the list of missing evidence that the prosecution has not turned over to the defense includes the following: video of Brad Holder's first interview, video of Logan Holder's first interview. This was Abby's boyfriend. The boyfriend. This is the boyfriend's dad. Data from Brad Holder's phone, video from Brad Holder's second interview, taken at the Logan Sports. So you can't go over there and blame that the shit wasn't working. Like, audio taken from Brad Holder's second interview. Any reports, notes, or documents concerning or referencing to Brad Holder's second interview. Mimicked crime scene photos observed by Trooper Purdy on Brad Holder's social media page, which I have all that. Images Ryan sent to Trooper Winters, April 12, 2017. Todd Click's letter, an accompanying 85-page report. It was held on to. And then, okay, finally, we have to give this up. Multiple Elvis Fields interviews. Rod. Multiple Johnny Messer. Multiple Taylor. Ned Smith. Libby German phone dump. Notice that all items A through G in paragraph 69 above are related to third-party suspects and Odinism. You guys remember us at the beginning here? Hey, as an investigator, you're supposed to eliminate, right? So do they get in on cross-examination to say, okay, during the course of this investigation, who did you eliminate that were on your radar? Objection. What? How about, well, how are you going to object to that? We're objecting now to the process, to the protocol. What we're objecting now to. How can you possibly object to that? During the course of this this investigation, you had to have interviews, right? Objection. I'm being serious. When people are out there going to be like, how does he going to object to that? Oh, I'll let him have it. Like, yeah, of course we did. Okay, so let's start at the beginning. How did you guys clear people? What was your process? Let's talk about that. Can you get it in like this? Well, you were aware that you're going to get in through the family. Mr. and, the grandparents, was your daughter in a relationship with anybody at the time of the homicides? Yes, no. They come to, Abby's family and say, Abby's like, well, yeah. Didn't she have a boyfriend named Logan Holder? Objection, relevancy. Like, yeah, she did. Okay. And can they get it in that way? I'm just trying to say, like, how can you be creative? How can the defense be creative to get it in? Logan, the Tim Burton character, yes. So I was thinking, like, okay, how do they do it? Let's help the defense. How do you get creative? And there's got to be ways that it would be relevant. And so, wouldn't you ask an investigator, or let me put it to you this way: wouldn't you then go out and get an investigator to be a rebuttal to the way that this to do best practice? So we're going to bring in so-and-so. He's our rebuttal witness to the way that they conducted their investigation. And let's talk about that. That's not how you're supposed to conduct investigation. And you start from the inner circles of everything, and then you work your way out, right? Is the key to go with the medical examiner, the time of the crime? Is there a way that you can get it in that way? Is if you have a medical examiner that comes in and off of the report can say, well, yeah, is it possible that this crime happened at this such amount of time? Yes. So how is that not enough? We have a medical examiner that's saying this. So the defense might not be able to say certain things, but if answers that are given by the witnesses of the state, I can't then say, okay, yeah, can we talk about who that is? Objection. What are you talking about? He just mentioned somebody that's the boyfriend of. Okay, so how did you eliminate that person? Wasn't there DNA at the scene? Did you take DNA? Wasn't there phones? Wasn't there geofence? Did you guys serve search warrants in this case on for cell data, tower dumps? Objection. You can't rebuttal if the state can object to you calling the witness based on the previous ruling, but I'm calling the witness based on best practice of investigation. And nowhere in there does it say that I can't have an investigator be used for the purposes of, talking about how reports would be done. And if all these people were eliminated, if they were at one point a suspect. So this is just wild to me. The state won't mention Logan Holder. I think that the state, it would, did you tell the police that your daughter was in a relationship and had a boyfriend? Yes. No. Who were the girls hanging out with? Who were they, talking to? Did they ever tell you anybody that they were dating, that they were friends with, that they were more than friends with? I'm just saying, is there a way to be creative? Can't bring up any prior suspects. That's the problem. Well, you can't bring them up. We could talk about best practice, though. This ruling is beyond a denial of a motion. It's straight up exclusion, unconstitutional. Yeah, I think it's straight up violation of someone's Sixth Amendment right? Nope, can't ask that. LOL, Nick will object. He's going to object to everything. But how do you get creative? Is there a way to get creative? Can you do it through the families? Can you do it through friends? Then let's take a look at this, which is let's go to the here we go. I won't even drive through Indiana. Here we go. The prosecution failed to turn over one of the key pieces of evidence for nearly 9 months, and then only after the defense kept requesting the prosecution for the same. A key piece of evidence in the case is the phone data extracted from victim Liberty German's phone. The prosecution and law enforcement had possessed that evidence for 5 years prior to Richard Allen's arrest, and therefore should have been able to provide that evidence immediately to the defense. However, the defense did not receive that evidence until September 8th, 2023, almost 9 months later than required under criminal rule. After the defense had a chance to review said data from the phone, it was determined, not believed, it was determined that exculpatory evidence existed in the phone that did not support law enforcement's timeline and supports that third-party suspects were involved in the murder. The failure of law enforcement to turn over Liberty German's phone for nearly 9 months, thereby concealing exculpatory evidence, the defense could have been exploring from the beginning, probably, right? The beginning of the representation of Allen is further evidence of intentionally attempting to conceal evidence and or evidence of bad faith. You guys, this is going to be so overturned. I mean, why are we even doing a trial? Unfucking believable. Unfucking believable. Okay. How about this? The time of the crime. Law enforcement concealed this report, Bloker's report, on April 26, 2024. The state of Indiana turned it over finally. April 26, 2024. This is a mere 4 days before this was written. This is from Steve Mullen concerning the findings of Sergeant Mitch Bloker of the Indiana State Police. Blocher. Why don't we just call him Mitch Blower? Contained in the body of that report was exculpatory information concerning ping information. That supports that on February 13, 2017, the victims were not located at the same scene as they were found on February 14, 2017. Oh my God. The failure of law enforcement in turning over this report for well over 1 year beyond when the prosecution was required to turn it over, and only after the defense sent a certified letter and filed a motion to compel, and for the sanctions demanding that the prosecutor turn over said evidence, is further evidence of intentionally attempting to conceal evidence and or evidence of bad faith. Bing, bing, ching. Now, you got Lesenby contradicting the sworn testimony of both Jerry Holman and Tony Liggett concerning the number of people involved in the murders, which goes to the Franks 1. And in Franks 1, it breaks it down. Both Liggett and Holman testified under oath that only one person, Richard Allen, was involved in the murder. This proclamation under oath by Liggett and Holman would negate the defense's contention that evidence supports that multiple people involved in Odinism were involved in the murders. However, when Lesenby was deposed, he stated under oath that Tony Liggett actually believed that multiple people were involved in the murders. So we can't talk about that. It's in a deposition. It's in a deposition. We can't use the deposition of an officer involved in this investigation, right, to impeach the affidavit of another officer that was involved in this investigation. Wait, what are you talking about? That doesn't even make any sense. Jerry Holman's August 10th. Jerry Holman got deposed in, I think, a couple times. Jerry Holman's August 10th, 2023 deposition testimony was false concerning the findings of the Purdue professor. And therefore, his testimony is evidence of law enforcement's. It's in the transcripts from November 2022 hearing. Yeah, wild. And what about Doug Carter still saying that they're all saying that there could be more people in their press conference? I just. Let's look at this. No recordings of Richard Allen's interview with Dan Dolan exists. In 2017, Dan Dolan has stated that he knew that he had audio recorded interviews when conducting interviews of tips and leads. Dolan claims that he now believes that he never audio recorded his interview with Richard Allen. I think I must not have audio recorded because all the other ones that I had are in a file on my computer. And I listened to each of them just in case they were mislabeled. Every audio recording I have, and none of them was Mr. Allen. So you're telling me that this can't come up? Can this come up? This interview is crucial, as what Dolan claims Allen told him, helped establish the timeline used to secure a search warrant and to arrest Allen. So can this be used to say, it's kind of like in the Dan Moore case, everybody was being interviewed, everybody was being recorded. They go to Dan Moore's office on March 24th and they just don't record that interview. Excuse me, with the chiropractor that you're going there to talk to canvas, and meanwhile you're interviewing everybody, but you just happen not to record that interview, or did you, and did you destroy it? The defense believes that Richard Allen was tape recorded and that the missing tape supports, again, intentionality on the part of law enforcement. I believe that it was recorded too, because why wouldn't it have been if every other one? But regardless, even if it was or if it wasn't, when you're going to come out here and say that all the other ones were, it kind of looks bad, right? So you're telling me that the jury's not going to know about this, or can they know about this? Hey, Sleuth the Goose, are you still in here? Do you have the order that Judge Gull gave yesterday? Because what does she specifically say about the geofencing as to why it's not being used? Okay, so I can go back to one of my old tapes here. She didn't give a basis. I knew it, that slut bag. God. Huh. Of course she didn't. She didn't say why. What a lunatic. God, I hope her career just goes up in flames. Unreal. She didn't give it. What else did I want to point out? Richard Allen cannot have a fair trial when exculpatory evidence that would support the involvement of third-party suspects is missing. And they're like, yeah, well, guess what? We're just not even, you know what? You're absolutely right. So we're just going to take it out. We agree with you here. So we're just going to make sure that this never comes in. And then it will seem like we didn't violate any right, you know. Only so many coincidences can explain why so much evidence concerning Brad Holder and Odinism is still missing, and why the prosecution failed to turn it over. It's just, you know, whatever. I can't wait. I can't wait till this case is over and this discovery comes out to the world, I guess. She is saying none of it exists, so they can't question them about it. It's ridiculous and unconstitutional, but they don't care about an appeal, and 10 years is just a conviction right now. Well, she's absolutely lost her mind. Indiana, shame on you. Indiana, shame on you. Indiana. You know, Richard Allen can give his discovery away to whoever the fuck he wants, unless there's protective orders on stuff. And from my understanding and reading these papers, there ain't shit out there about it. So, one more time for the cheap seats. Let's move this. So on Monday, join me. What is left? Teresa from Criminality. I'll message you there. Sleuthy Goosey, join us. It's going to be a good show. I still cannot believe she said his conditions at the prison didn't cause any mental trauma. Yeah, she's a fucking idiot. I mean, anybody, when you have mainstream media, okay, all on the WTF, okay, then you know it's that bad. But here I want to bring in this last part. Close with one of my Brad Holder. I did a Brad Holder episode, and I took his whole socials. So let me go pull this up, and I want to show the Brad Holder episode that I did. It just gets at the end when I do it. Oh, wait, it's not this one. Hold on one second. I think it's under my Delphi playlist. If you go there as well, all my old stuff is there. Delphi. Well, it should be there. Wow. Almost there. I did a lot of episodes of Delphi. I need to put all these in a. Tony Liggett lies about Betsy. That's a great episode. Doug Carter's fake tears. Another great episode. Oh. I'm gonna have to. I think it's this one called Patsy. This whole jeez, I'm gonna have to look for it. I go through his whole social media. Hold on, I want to take one more look at this other one. Damn it. Jeez. Patsy framed. Let's see this one. All right, maybe it's this one. Okay, yeah. Got it. All right, I found it, guys. Sorry for the delay. Doug Carter. It's under Doug Carter's fake tears episode. God, when was this from? Right there. Look at that. What's that date again? See that tree? Okay. Brad Holder is in Logansport. February 17th, 2018. See that beginning when he wrote there? I want to stop it. See that tree? Okay. Well, I started back February 17th, 2018. Yeah, that's what I thought. Okay. You see the way that this is laid? It's like the L shape. Again, you guys can find this on, if you go, it's an episode called Doug Carter's Fake Tears, Delphi. But none of this is relevant. This is the crime. This is like the crime scene. April 30th. Look at that. 2017. Just rounding them up, man. And this is when I was reading through. This is that part of that Frank's. Once both bras were secured onto Abby's dead body, this man acting alone would have to locate the pink shirt that Abby was wearing underneath the sweatshirt. Once the pink shirt was located, the man acting alone would likely have positioned Abby's arms above her head to make it easier to place the pink shirt onto Abby's dead body. Like all of this, like this
that
is
shirt whatsoever.
that's the part of it that's just wild to me. Is I don't believe that one person could, like I think that that's really compelling. Breaking that down, talking about that one person only did that, and then here I break down his social media again.
Communication, inspiration, ancestors. Is that what that is? Make sure it's coming up on your guys' end. There we go. I believe it is the way of the European people to view the male and female as equals. Or I like to view it like this. The woman is everything I'm missing in my life to be complete. I will never be able to give birth.
Oh, yeah.
And as we are proud of our ancestry.
Where's that part at? What's this one? Did that one.
But I'm pretty much an open book.
Okay, so May 20th, 2017. So this is to all you trolls out there. I was at work the day that all of this took place. Not that I owe any of you anything, but I'm pretty much an open book. Me or my son would never do something like this. If I figure out who you are, I will seek legal action. So keep talking shit.
So the reason I'm showing this is because who this Brad guy is, and because I'm going to go back and read from the beginning for you guys, some of it. This guy is the father of one of the girls' boyfriends at the time.
This is a show I did back.
So this isn't
whenever
just
this
some
came
like
out.
random. This guy actually has a connection to the girls.
You would think. Nope. Judge says
But-
no.
So people were saying back in the day, I mean, this is May 20th, 2017. Me or my son would never do something like this. If I figure out who you are, I will seek. Okay, I have a Facebook stalker that has accused me, my son, and is now, since my story checks out, accusing my friend of killing Abigail Williams. And
You guys, this is back May 5th, 2017. Never does he ever say, I was down there, I was interviewed, they cleared me, we've cooperated with police, we've given them everything. He doesn't say that on any of his posts, does he? No.
German. My son was totally devastated and heartbroken that his girlfriend had been murdered. Besides their
his girlfriend had been murdered. His own words. So someone's going to try to say like they weren't dating at the time. Well, there you go. His girlfriend.
families, there is probably no one that wants to see their killer brought to justice more than I do. Maybe since you're pointing fingers, you are the one who did this, you sick fuck. My suggestions is that if you did this, you turn yourself in, because I know some pretty mean folk that don't like
Chomos. Oh my God.
chomos. Excuse me. Okay, again, May 5th, 2017. Brad was pissed off. Now,
Brad was pissed.
Now we're going to get into this investigation.
Yep,
Okay, we're going to get into this investigation.
This actually we're not, because there was no investigation. Let's go to the part where I show some more. What else? There's another episode that has more of it. But you guys get the gist. This was going on back then. So, want to end with this though. Where's it at? There we go.
and when that crucial time period actually was.
And before I let you go, remind us the trial date is
October 14th through November 15th. It'll start with jury selection in Allen County, which is Fort Wayne, Indiana, and then the rest of it will be in Carroll County where the crime happened.
All right, Barbara will be there covering for us, Court TV. Thank you, Barbara McDonald. Let's bring back in Tad Thomas. Tad, your thoughts on this case and specifically this latest setback for the defense. Now, we should remind people that the defendant, Richard Allen, reportedly confessed multiple times to multiple people. There is some there for the state's case.
Yeah, that's right. But this is a devastating blow, really, for the defense, isn't it? And what people need to know is
it's a devastating blow for Americans. Okay, it's a devastating blow for Americans. Call it what it is. This is not just about Richard Allen. This is about our rights. This is a devastating blow for all of us that live in the United States of America, especially guys living in Indiana. Whew, shit. I mean,
the judges have discretion to keep out irrelevant evidence. It's not that the defense just gets to come in and throw anything they want at the wall. The judge has the right to narrow the proof to something that is a legitimate defense. And I agree wholeheartly that, hey, this case is going up on appeal. This type of a major ruling is certainly something that's going to go up if there's a conviction, whether there's confessions or not. But the judge has a right to narrow the evidence that's coming in, and the prosecution shouldn't have to, fight ghosts. And
narrow something? Yeah, you can't eliminate discovery. You just can't. You know what? This looks really bad for the prosecution. So we can't have this. But
prove or try to disprove something.
Join me on Monday. I'm going to make a post for the promo for the link. Join us. Bomb panel on Monday. The Delphi timeline criminality will be here and taking your guys' questions. And the big thing is what's left. How do you defend Richard Allen? What's left? Yeah. Wild, right? No justice, no peace. You can't just eliminate it because the state says something is confusing. Exactly. They're going to be the most confused motherfuckers. And you could tell them, hey, go read the directions to put a fucking basketball hoop together. They're going to be confused. I think we've seen more hairdos by Nick during this case. I've seen him worried more about his looks in this case than doing right by anybody. I mean, how about the leaks? How about there's freaking blood on these people's hands? Like people were either committed suicide or people were just murdering people after the fact because of discovery leaks. Remember that? Come on. Why? All right, guys, join us back on Monday if you guys want to talk about the Delphi case, and I will put out that promo clip so that you guys can get notifications. See ya. Thank you, moderators, by the way. Thumbs up the video, share it. This is actually a travesty for all Americans.
Today is not a day to celebrate, but the arrest of Richard M. Allen of Delphi on 2 counts of murder is sure a major step in leading to the conclusion of this long-term and complex investigation. Of this long-term